so getting right into it, we've got two forms that we're going to cover today. The first one is the notice disclosure. The second one is the cure. I will, of course, have this recorded and sent out later, but I definitely encourage everybody to take a look at these two documents, primarily because I think they are both underutilized. And there's actually a variety of ways in which they could be used and realistically should be used. So let's get right into the notice disclosure form. There are numerous references to give notice in the contract. Just in the PC itself, that word notice actually appears 48 times. Now, some of those things which a party has to give notice to another party about have their own respective forms. Okay. Your unfulfilled loan contingency serves as a notice, the appraisal contingency notice, the BINSR. These are individual documents that satisfy notice or disclosure, like the SPUDs, for certain things. But then we have a few generic things, and I'll talk about those in detail, that aren't covered under a specific document. And in those cases, previous to this form being made available in 2019, we would just satisfy that notice requirement by a Word document or an email, something that wasn't specific or an AAR drafted form. So AAR gave us an actual document to utilize for those purposes. So, as with everything, this is a copyrighted document, so you can't just hand this off to people. It is only to be used by realtors. So, if you are not a realtor member, if you are part of the non-member MLS access, you do not have this document or will not be able to utilize this document. So, this is exclusive to my realtor members on the call. So this notice disclosure, this form can be used by either party to deliver notice to either party. So it has it broken down here. This notice disclosure is originated by either the seller or the buyer. And then it's fill in the blank information. So your contract date, the seller name, the buyer name, the property address, and then just generically, the undersigned party hereby provides the following notice or disclosure. So whatever that notice or disclosure is, you're just going to type it right into those blank lines there. Now, keeping in mind, like so many other things, especially the cure notice that we're going to go through, this is not intended for a short story. Okay, this isn't being submitted somewhere for the best narrative. All you have to do is provide whatever that singular notice or disclosure is without getting into too many wild details or trying to concoct anything else. Just deliver the notice. So I'm going to open it up a little bit to all of you on the call. Can anybody, just off the top of your head, think of an example of something that the contract says, and it may not be just the purchase contract, it could be on one of the addenda, where one of the parties has to give notice about something to another party, and it doesn't have its own form. Does anybody have an example that they think of?
Is this kind of similar? I mean, on number 6, it says, the party hereby provides the following notice of disclosure. What's the difference with the SPUDs and then this notice disclosure, just saying that you disclosed also the SPUDs?
No, so this would be used for things that, although Jazz, I'll give you because you're actually hitting on one of the things. So the seller has to provide the SPUDs. Okay, that's a lengthy document of disclosures, and ultimately there may be things that change during the course of them having their home listed or while they're in contract,
Okay.
and the contract says, hey, the seller must provide an update to those SPUDs. So this is the perfect document for providing that update. So they don't have to do it on the SPUDs itself. While that's acceptable and they could date it, they don't have to do it that way. They certainly don't have to redo the entire SPUDs to include those updates. So this is the perfect document to use when maybe they just had one or two changes. They went forever without ever seeing termites, and then all of a sudden they went out to their garage and they found that there's a termite tube in there. This is the form where they would then be able to update their SPUDs with just that one disclosure about having found the termites and then any corrective action that they had taken for those termites. So that is probably the number one use for this form, is when a seller has to update their SPUDs. This is the form that they would do that on.
Okay, thank you.
You're welcome. Anybody else? Can anybody think of something that the contract requires a notice for?
I was thinking maybe something to the effect of people got divorced or something in the middle of the process.
So that's actually a great point. It depends on the circumstances, right? So if it's a divorce that is not going to impact the sale, then that is actually confidential information and nothing that needs to be disclosed. However, if the divorce is going to impact the sale in some way, shape, or form, that would be another story. Admittedly, I'll go on record as saying if they're already under contract, whatever transpires with the divorce cannot affect this deal or the transaction because they've already both signed agreeing to the terms contained therein. So failure to perform for personal reasons, and a divorce is a choice, it is a personal reason, would actually open that seller up to liability for performance as well as damages. So Kathleen, I think that's a great example that ultimately, depending on the circumstances, that might be one of those, but it shouldn't be.
What about bankruptcy?
Bankruptcy would be a different scenario, especially if it's on the buyer's side. If they decided to declare bankruptcy while they were in the midst of closing, that's another arguable situation. On the seller side, they're going to be kind of in the same boat. Had they already signed a contract and they elected to go into bankruptcy after having signed the contract, what they needed to do with their bankruptcy attorney or the court or whatever was have the property held exempt from that, because they would need to still go ahead and proceed with closing.
I guess that leads me to another question. What if, husband and wife were selling the property and one of the people passes away?
So it depends how title is held, but same sort of circumstances. If one passes away, that was obviously intention because they signed in the first place. So we're going to, in this example, I'm going to assume that they held it community property with right of survivorship, in which case it just continues. Depending on how they have title, if somebody else has to be brought into that, they would still be obligated to perform, but now we're going to have some court approval if there's like tenants in common or something similar. Any others?
What about if there's a buyer contingency and that contingency doesn't close on the date that it was supposed to? Would you use this form, or is that on another form?
Yes. Yes. No, that is so. This is probably, I would say, the buyer contingency addendum stuff. It references notices a lot, and there's no specific notice document that was created for those. So, my second sort of favorite or most likely use of this form would be for all of those notices that are referenced on the buyer contingency addendum. So, as an example, the buyer is waiving their contingency if their contingent property does not close on time. Because the property did not close on time, they have to deliver notice of that failure to close on time. They're waiving a contingency after seller receives a backup offer, or offer on buyer's contingent property canceled. So there's half a dozen in that buyer contingency addendum that would be covered then by this notice. So 100%, this is a great time. If you're doing anything with a buyer contingency addendum, know this form and make sure you're aware of all of those different notices that are required and the points that they're required, because this will absolutely come into play. Any others? Okay, let's go through a little list that I put together. This is not all inclusive, but it'll give you some ideas as to what to keep an ear or eye out for when you're in the midst of a contract. So as we discussed, the seller uses it to update their spuds, probably the number one use of this form. There is an opportunity for buyer to disapprove of items after their inspection period has passed. Okay, so if during their inspection period, they're using the Binzer for this purpose, right? But let's say that there is an update to something after due diligence has been completed. So a couple of scenarios. The clue was received late. And by clue, I mean the claims history letter or the loss history letter, something to that effect. Most agents still refer to it as a clue, but technically it's the claims history letter. So if that is supposed to be delivered during the buyer's due diligence period and actually within the first 5 days of contract acceptance, if it isn't for whatever reason, ideally you're going to cure, which we'll get to next. But even if it passes that date or they're just waiting and they can't seem to get it from their insurance company in a timely fashion, then the buyer has 5 days from receipt of that claims history letter whenever it is received. And if they receive it late after their inspections are over, then they would use this form as a notice of cancellation if that is their intention based on items of which they disapprove in that claims history letter. So there's a lot of buyer disapproval items. Another one is if the affidavit of disclosure is received later. If there is an update made to the SPUDs and the buyer then is disapproving of that update and they elect to cancel. They disapprove of HOA documents that are received late, or title commitment, or subsequent exemptions that are given by the title company through the title report, or anything that develops after the fact. So any of those buyer disapproval items that occur after the inspection period is over, that disapproval and cancellation would go on this form. So with that, I'm often asked, where is the cancellation form inside Transaction Desk or SkySlope forms? There isn't a cancellation document. There's nothing labeled cancellation form. So oftentimes you will have a designated document for cancellation, right? So the BINSR, the buyer could cancel on the BINSR. The buyer could cancel on their appraisal contingency notice. The buyer could cancel on an unfulfilled loan contingency. So there are several forms already in place for those purposes. However, for these other ones where we're discussing buyer disapproval of things, this is the form that would be utilized for cancellation. Additionally, this is the form that would serve as notice of cancellation if one of the parties issued a cure notice to the other party, the cure period lapsed, and now that issuing party wants to cancel. So same thing. So for all intents and purposes, keep in mind that this is one of those cancellation form options without being named cancellation form. On the additional clause addendum, it says, upon cancellation of the prior contract, seller shall promptly deliver written notice to buyer. Upon buyer's receipt of written notice of cancellation of the prior contract, buyer opens escrow, yada, yada. Okay, so there's a couple of notices just in that one backup contract clause. So again, this is the form that would be used in that case for the seller to notify that to the backup buyer, hey, first buyer canceled. And then obviously that notice is now going to serve as your contract date for that new backup buyer. Any disapproval of survey results, especially if those came, and those likely would come after the buyer's inspection period. So that would also go on here. And then as Tammy had already brought up, there's a ton of buyer contingency addendum stuff that would be addressed then through this notice disclosure form. So whatever that notice or disclosure is, you're, like I said, summarize it and go ahead and write it into these lines 7 through 16. There's space there for you. I do recommend always prefacing your notice or disclosure with per or pursuant to this line or this section of the contract. Here is the updated disclosure. Here is the notice. So you're referencing why this notice is being put into action so that everybody is abiding by the same timelines. And then it references a total of blank pages is attached, and as part of this notice disclosure, there's a good chance it's just one. And that one is this, in essence, cover notice disclosure itself. If you need additional forms, though, especially if it's an update to the SPUDs and maybe you have receipts, invoices from contractors, or more of an explanation, something similar, then you may have additional pages that you would attach in that case. And then it's just the signature. So this is the most critical part of this form that is so often misunderstood. This is a one-party notice or disclosure. So only the party issuing it needs to sign it. This is not signed by the party who is receiving it. And just in case you forget, line 19 actually states this form is unilateral in nature and is to be signed only by the party originating the notice disclosure. Questions?
So after
I have,
either
Oh.
either or, if it's a buyer or seller, whoever it is that's signing this disclosure, then you'd go ahead and forward that to buyer or seller.
Correct. So let's say that this form is being originated by the buyer. Okay, so they're going to write the disapproval of whatever they want to write in here and effectively cancel the contract. Once they sign this, this form goes to the other side. So in this case, it would go to the seller as well as it would go to the title company because it's serving as written cancellation in that scenario. But yes, this would always be signed by the party issuing it and then needing to be sent and received by the party that in essence it's against.
Okay.
Sophia, you had mentioned that this form can be used if somebody needed to update the SPUDs.
Correct.
So it gets filled in and signed by the seller. It's unilateral, but what document would the buyer use to acknowledge receipt of the disclosure?
So they don't need to acknowledge receipt in writing. I get what you're saying, Adriana, and from a CYA perspective, I kind of like that as well. However, updates to the SPUDs are just based on delivery and receipt by the other party. They don't, while we have them acknowledge the original SPUDs, they don't actually have to acknowledge any of those updates. So if there is a problem, their course of action would be to deliver a notice disclosure to cancel based on their disapproval of those items contained therein. But as long as we can prove that we sent this to their agent via email, ideally with some sort of acknowledgement from the email regarding received, then ultimately we've done what is required of us.
Okay, that makes sense. So with the lack of an official cancellation form, if the SPUDs have to be redisclosed, therefore the buyers would have an additional 5 days to disapprove, correct? And
Correct.
let's say that they did want to cancel, what form would they use at that point?
This form. So the SPUDs is a kind of a tricky one because there's two parts to that. The buyer just can't simply cancel based on the update to the SPUDs in some cases because the contract also says, hey, the seller has an obligation to maintain and repair the premises so that it's in substantially the same condition at closing as it was at time of contract. And any of those things which they are required to repair and do repair, then ultimately, while it's an update to the SPUDs, there's a clause in the contract that references, but the buyer can't cancel for those reasons. So there really would have to be something that couldn't be corrected or repaired by the seller that's serving as an update. While I think there's some arguments to this, so some of the wild ones would be wildlife on the premises. I mean, yes, you could remove something, but ultimately there's no knowing that there wouldn't be something again in the future, especially bees. So there are certain things that the buyer would have more pushback on if they try to cancel. But that was a very long answer about there's some nuance to buyers canceling over updates to the SPUDs. But ultimately, this is the form that they would then use to state their disapproval and cancellation.
Okay, thank you.
You're welcome.
Can this notice of disclosure can be denied the request?
So tell me a little more about, because this isn't a request, this is in essence just stating a fact of something. So do you have a specific example in mind?
Let's say for the example you mentioned about divorce, and maybe if they say, okay, we're getting divorced and then we're changing our mind if it's a buyer, can that be possible for the seller to accept that statement?
So probably not. So again, bear in mind, divorce is kind of a rough example because there are no protections for either party in the case of divorce. That is something that they chose to do. So if the buyer is going to be denied a loan because they chose to get divorced in the middle of buying a home, then they shouldn't get their earnest money back. And if the seller is trying to get out from selling their home when they're already under contract because of a divorce, they would be putting themselves in a situation where they can be sued for performance and damages in that case. So if there is a situation where it's not a clean cut cancellation option and we don't want to sell the house because we're getting divorced is not an option for cancellation, they would actually need to use a standard addendum to mutually cancel the contract if the buyer agrees. And if the buyer does not agree to mutually cancel the contract, that's when lawyers start getting involved to handle what this looks like if the buyer still wants the house.
Okay, thank you.
Yeah, divorce is a complicated situation in the midst of a purchase contract. So that's definitely one of those. As soon as we start hearing that, we'll give our initial advice just so that they understand what could happen in that case. But then ultimately, it's time to speak to an attorney to really understand recourse and your options in pursuing this if you choose to do so. But this form isn't really one. Like I said, divorce should be confidential. If it's going to impact the sale, then what is going to be impacted needs to be disclosed. But ultimately, that may not matter because the parties are still obligated to perform. So I don't think this would be utilized in a divorce situation for any reason.
Yeah, because that'd be a breach of contract.
Correct. It would be a breach of your fiduciary duty to disclose that your parties are getting divorced. Like I said, unless that's somehow going to impact the sale, but it shouldn't legally impact the sale. So really, it shouldn't have to be disclosed at all for any reason, unless it is, hey, my sellers tell me you have permission to share this because we are hoping that the buyers have some heart and that they'll be willing to let us out of this contract based on the circumstances. That's the only time that you should disclose that you have a party getting divorced, is with that permission. And then the follow-up would be you still wouldn't use this form. You would need an addendum to mutually cancel the contract.
I have a question, something that kind of came up when we bought our house here in Surprise. What if a seller doesn't disclose that they're in the air traffic pattern for Luke Air Force Base, but the buyer, it's obvious to the buyer that they are in the flight path?
Yeah, so disclosure is a wild thing. It's kind of a gray area. So while that may not have been specifically disclosed on the spuds, the buyer ideally has been given a buyer advisory. And within that buyer advisory, there are links to airport maps and noise contour maps, etc., that would have disclosed that. So there's maybe an argument there, but on the flip side, Kathleen, to your point exactly, if the buyers are aware of it, we have this thing in disclosure law called point of discovery. And even if the seller didn't disclose it, but the buyers were made aware of it during a time that they could have ultimately gotten out of the contract, then that point of discovery was made. Disclosure was made, albeit not from the seller, but the disclosure was made. The potential issue was made known to the buyer, and they elected to proceed. So there's not a black and white. There's nothing that references in our purchase contract point of discovery, but if it ever goes into litigation, that's what they're looking at. So was the buyer aware? So with reference to this form, does the seller, if the buyer is aware of a problem or of an issue or potential issue or something that exists, if the buyer is already aware of that, let's say through their own due diligence, through their inspections, through just sitting out at the property and hearing the jets, and they notify the seller, does the seller then have to fill out this form with that disclosure? For that buyer, no. So we're not in essence looking to extend the timeline for the buyer to have the option to cancel. Their point of discovery was on Tuesday when they were out there and they heard the jets. They made us aware of it. So ultimately, we know that they know. And they still decided to go ahead and proceed. They can't all of a sudden come on Saturday and say, hey, you need to update your spuds and then try to cancel that late in the game. So there's a timing component. There's the point of discovery component. However, if this buyer backs out or is legally cancels or not, whatever the case may be, and our seller goes under contract with a new buyer, those discoveries through the previous buyer's inspections or comments to us, is assuming that they're latent material defects or they're referenced on the spuds somewhere, those updates need to be made for that new buyer. Does that make sense?
Yeah, thank you.
You're welcome.
Hey,
Yeah,
Leah.
disclosure is not as black and white as people think it is. It's a tough one. Yes.
None of the financial changes need to be necessarily disclosed as long as it doesn't affect the close of escrow date, correct? So like if they're going to use a 1031 exchange and then they don't, that doesn't need to be disclosed. As long as all of the stuff is staying the same, none of that needs to necessarily be disclosed.
So not necessarily. There's a difference between agreement and delivering notice. So if there are changes to any of the loan stuff set forth in the prequel or the LSU, the great point, those should be delivered on a notice to the other party, if assuming that this does not change anything on the seller side. So it doesn't change the seller's costs, it doesn't change close of escrow, etc. So assuming that is true, then the buyer still must deliver notice of those changes, but they only need to deliver notice. They do not have to have an addendum signed. If those changes would impact or adversely affect the seller in any way, then those changes would require mutual agreement via addendum. Good job, Tammy. You caught a really good one that I didn't even have on my list here. So updates to buyer's loan. We'll make a little note. Should also be delivered on this notice form. What else?
And in some cases, is an email enough for that? Or do you recommend we still do it on this notice of disclosure?
Yes, so just for everybody's sake, understand that an email does constitute sufficient delivery of a notice. Okay, that is acceptable. This is better. This is better because in essence, it's not coming from us, it's coming from the party to the contract about that respective notice. And in the case of cancellation being involved, then this also serves as written instructions from one party to another and to the title company so that they have the form in place to actually cancel the deal.
Got it. Thank you.
You're welcome.
Hi, Leah.
I
I have a question. What happened is in the walkthrough, is the seller decided to repair something, but when you go to the walkthrough, it's not. So, and he decided not to do it. We can use this or not?
No, so in that case, that is a contractual non-compliance. So that won't be on the notice disclosure. That's actually going to be on the cure period notice because we need to cure the other party for failure to comply with a contractual provision.
Okay, thank you.
You're welcome. So on that note, anything else about the notice disclosure form or the many ways in which to use it before we move on to the cure? All right, let's do this. My favorite form, I call this a love letter. And I call it a love letter because really, we're just trying to get the other party to comply with something. So the cure period notice is telling a party, hey, you are currently in non-compliance, but you are not yet in breach. So in almost every situation, a party cannot be in breach until a cure period notice has been issued and the 3-day cure period has lapsed. I have come across a couple of things in the past where they are considered immediate breaches because there is nothing to cure. One such thing would be wrongful cancellation. So in essence, if a buyer cancels for reasons that they are not within the parameters of the contract, that cancellation that they delivered is considered final. So you wouldn't cure for, hey, you have to not be canceled. You have to wait and then do something else. No, that cancellation was immediate. And if it was out of compliance with the contract, then that means it was an immediate breach as well. But typically speaking, if one party hasn't done something that they're supposed to do, so like in Myrna's example, if they agreed to do certain repairs on the Binzer, we're doing our final walkthrough, and assuming the final walkthrough is done within the parameters, which is 3 days prior to close of escrow, okay? If you do your walkthrough 7 days prior to close of escrow and repairs aren't done, that's not the seller's fault because they have up until that 3 days to complete the repairs and give receipts. But we're going to assume that we're all in the right here. So on that, then that cure period notice would be delivered, and the non-complying party would have 3 days to remedy the situation in some way, shape, or form. So the top of the cure notice, contract date, buyer, seller, the escrow company, and that's because all cure notices must be delivered to the title company. The premises property address, pursuant to the remedy section of the contract, buyer or seller, okay, you're marking a box, whoever you represent that's delivering this, hereby delivers notice to the buyer or seller of the following non-compliance with the contract. So again, this does not say breach, it says non-compliance with the contract. That's why I call it a love note. We're just sending this over to the other party so that they understand they're in non-compliance and that they have the opportunity to correct this non-compliance before it becomes a breach of contract. Because once it becomes a breach of contract, then we start going into other remedies like arbitration.
I like that. The love note.
People think that this is such a nasty way to conduct business. I'm like, well, just call it a love note for compliance, and then maybe you'll feel better about delivering it. Because if your fiduciary duty is to make sure that the other party is complying so that we can all close on time, right? So that everything can be done in accordance with the contract. So don't be hesitant to send cure notices when they need to be sent. And just to give you some examples, if you're not sure what is a curable offense in our contract, this amazing critical date list from AAR breaks it down for you. Not only does this show, hey, based on the contract acceptance date, this is when something's due, this is when it was completed, but if you look off to the left side here, see this little square that has the letters CN in there? If there's a CN by this, it means, hey, if this wasn't completed by the date required in the contract, you can issue a cure notice to the other party for failure to comply. So many agents are hesitant to do this, again, because you think it's mean. It's not mean. I have a duty to represent the interests of my clients, and your client not performing is making a violation of a contract that I am obligated to help uphold. So we just want to make sure we're not doing it to be nasty. We're just saying, hey, love note, you didn't comply, you need to comply. Here's a little note to remind you that you need to comply, and you'll have 3 days to do it. Let me go on record as saying, while I love issuing cure notices, I hate that we have them. I think that the cure period is so confusing for really most states, but buyers and sellers, right? Because as soon as something's not done that was supposed to be done per the contract, our immediate and their client immediate reaction is the other party is in breach of contract. And because they're in breach of contract, I should be able to do something about that. So it's very frustrating to them, especially when it comes to close of escrow, that it's not an immediate breach of contract. We still have to deliver this notice and give the other party an additional 3 days, sometimes more, to comply with the contract. So make sure that you're explaining this when you are presenting offers to sellers, especially, but also to buyers, so that they totally understand this is how this works in Arizona. So just know that even though they were scheduled to close on Friday, which by the way, don't ever do. So many of you schedule closings on Fridays and at the end of the month, and it is the worst possible time to do this. I understand from a buyer's perspective. In essence, they're looking at it as saving money because they're trying to get it so they don't have to make a mortgage payment for however many days after. So they're trying to pay all of that upfront through their closing costs that the seller might be contributing to. I get it. On the flip side, we have more issues with Friday and end of month closings than anything else, because what happens if closing doesn't occur on time? Now you're rolling into days where closing cannot occur and everybody's upset. So prime example, this was a holiday week. So let's say that we had our closing scheduled for Friday and we didn't close on Friday for some reason of the buyers. Okay, the buyer didn't close because they didn't get their loan approval in time or something similar. So you can't issue the cure notice until the following day, because technically they have until 11:59 p.m., even though they cannot close after 5 o'clock. So you have to wait. You have to give them their full day per the contract. You cure for failure to close on Saturday. So now day one is Sunday. And now you're going into Sunday, Monday, Tuesday, they have to close escrow. That is way different than Friday. And even if they had been slated to close a couple of days sooner, so let's say they were slated to close on Wednesday in this scenario. So in that case, we cure on Thursday. Friday is day one, Saturday is day two, and Sunday is day three. But they can't close on Sunday because the county recorder's office is closed. Monday was a holiday. The county recorder's office was closed. So even though they were supposed to close on Wednesday of the previous week, we're now pushed out until Tuesday, and legally the buyer has that time to get the deal closed before they would be in breach of contract. Do you think that would be upsetting to a seller to have almost a week delay with their close of escrow with no recourse whatsoever?
Yeah.
I think so too. Not only do I think so, I know, because I've been yelled at and screamed and everything else, because I have to be the bearer of bad news in these cases, to let the seller, specifically about close of escrow, know they have this time to perform. So again, just make sure that your buyers and sellers are understanding that, with few exceptions, we really have no immediate breaches in our contract, which means that if something is not done on time, we still have to deliver this cure period notice, which then gives the other party the 3 days to perform. And look at all of these curable events. I could probably create more, even depending on different addenda used. And then we can get into wild things like anticipatory breach and go through cure noticing for that, which is another whole ordeal. But there are so many cure notice opportunities here that our clients need to be aware of, so that when that non-compliance occurs, they understand at this point it's just a non-compliance, it's not yet a breach, which means it's not rendered to cancellation or damages or anything else. How many of you have looked at or seen this critical date list before?
I
Anybody?
have. Yes, I
Yeah.
have.
Excellent, excellent. I'm gonna put in the chat here. So this is where you need to go. It's just aaronline.com. When you get there, put in the search bar, critical date list, and this lovely thing will pop up for you. I strongly recommend just saving a copy. It does update anytime there's a contract update, just as a heads up. Saving a copy of this to your desktop so that you can quickly reference it if there's ever a non-compliance with the timelines. But if I were still actively practicing, I would have one of these at the onset of every contract I have. I'd fill this out and I'd go ahead and start putting in my dates and checking this off. I think this is such a great task manager for ensuring timely compliance with contract terms. So it's very helpful. This is also, I tend to get a lot of questions about how long does this party have to do this? Like, this even answers it for you. 3 days after contract acceptance, 5 days after contract acceptance, breaking it down. What was your inspection period dates looking like? 5 days, 5 days, 10 days, all of these different things. So it's just a good reminder of your timelines as well. All right, so we're putting in same thing with the cure notice that I referenced with the notice disclosure form. Do not use this as a means to modify the contract. Okay, so you're not creating some long ass story about what the buyers did and how horrible they are and all of these things. No, reference the line that they are out of compliance with on the contract. Per or pursuant to this line, buyer has failed to. Per or pursuant to this line, seller has failed to. That's all it needs to say. So, as an example, even going shorter and sweeter, for buyer failed to close escrow, this would literally say seller delivers notice to buyer of failure to close escrow on such and such date. That's it. That's all it needs to say. What you cannot do is say buyer shall pay $250 per diem or an extra $1,000 for the delay in closing, or none of that. You're not creating contract terms here. Those have to be agreed upon with both parties in an addendum. This is solely to serve as a notice of a non-compliance with the contract. So you're just pinpointing what that specific non-compliance is. If the non-compliance is not cured within 3 days after delivery of this notice, the cure period, the failure to comply shall become a breach of contract. In the event of a breach of contract, review the remedies section of the contract and consult independent legal counsel. Okay, so they're reminding you, could be small claims court, it could be arbitration, it could be mediation, but ultimately, that's kind of where the buck stops for us. We can let them know these are potential options for recourse should you desire to pursue them. However, I do not practice law, so you would have to consult with an attorney for what recourse looks like. Anytime somebody mentions the word recourse, be hesitant to respond, because we don't deal in recourse. We deal in contract compliance. What do we got? Questions about the cure? Who wants to tell on themselves and say, hey, there are times I should have cured and I didn't because I thought I was being mean? You're all a bunch of liars. I hear that more often than not.
I can't think of a time I've ever needed to cure anybody. I guess I'm just nice and I just ask for it first and then they do it on time and then I don't have to cure.
If that is true, Tammy, that is amazing to have as much business as you've had and ultimately not have somebody be out of compliance. Are you sure it's not because you're too nice?
I don't think so. I can't think of a time when I don't know. I'm a type high C, so I do like things done on time and I can't think of a time that I've had to cure anybody. Knock on wood, I guess.
Well, so to your point, I think that that's a valid consideration as well, right? You can always start by asking. However, bear in mind that the longer you delay curing for something, the more danger you potentially put your client in. So while it's okay to ask, don't keep asking and keep asking and keep asking. If after you've asked once, they haven't provided that within a timely manner, and I'm thinking like 24 hours, I'd be looking to issue a cure notice to make sure that you're getting what you should be getting for your client.
Yes, of course.
What I have seen, one thing I do want to share is what I have seen is if the buyer fails to close and the seller cures them, therefore they now have 3 days to cure the non-compliance, and they come back with a loan denial letter because they had those additional 3 days, and now the seller is upset because the buyer was able to issue a loan denial letter and get their earnest money back, and there's no closing.
Yeah, and that's a great point, Adriana. So this leads into another consideration here. That situation should have been cured for failure to comply with Section 2B long before we got to the close of escrow date. So, in my opinion, that listing agent waited too long to issue the cure. Because while the sellers absolutely would be frustrated if a loan denial is issued at any point that close to closing, it's even worse when we are now past closing and they have paid for movers and everything else. And now we are past closing and the buyer is still able to cancel and get their earnest money back. That is the most difficult thing to have to explain to a seller why. Had that listing agent cured for failure to comply with Section 2B the full 3 days prior to close of escrow, we would have at least known that yes, this is potentially happening or no, it's not. So while they may have remedied the 2B component of that, then at least we know, okay, the CD's out, they have final loan approval, we do have a closing in sight. In the situation where they waited and only cured for failure to close, they didn't realize that we were that far behind that it wasn't even an option. And in some cases, they may need to cure for both. So the 2B was up front. Yes, they remedied that, but now closing is not occurring on time. And now they need to cure for the failure to close. But that cure cannot be remedied by a loan denial because we already have verification because of the initial cure that ultimately says, no, they have final loan approval without loan conditions. So if they try to cancel after that, it's going to be an invalid loan denial.
Got it. Thank you.
These are whirlwind crazy situations, but they happen all the time, right? So that's why we want to make sure that we're using the cures effectively. And again, not being, oh, they said they're going to get it to me tomorrow. Great. Then by me issuing a cure for failure to do it today and is not a big deal, right? Because they've already said they're going to get it to me tomorrow. Fabulous. So they'll remedy it tomorrow. But if they don't, which very often happens, they overpromise and underdeliver. At least I've already put my client in a position where they can take action if the timelines are not met. And that's the goal. One other thing to keep in mind with this, a cure notice does not cancel a contract. Okay, this is simply a notice of non-compliance. To cancel the contract, there needs to be an additional document. It could be that notice disclosure form we covered. It could be the appraisal contingency notice. It could be the BINSR. It could be something else. But this form does not cancel a contract. So just be aware, even if you utilize this in the 3 days lapse, you ultimately will still have to have some form, some document stating that the transaction is canceled due to the breach of contract after an expired cure.
Leah, I also wanted to add that since we deal with and manage emotions throughout the contracts, there are times where agents don't want to cure early on during the inspection period. for non-compliance, let's say deposit of earnest money or something else that happens early on. And the thought process behind that is that they don't want to upset the other side before they have to negotiate the Benzer.
I get that. And I think that there's a couple of ways to address this. So first and foremost, all of these notices need to be approved and obviously signed by your client, right? So ultimately, I think that that's the conversation to have, that, hey, contractually, you are granted this option to deliver this notice to try to enforce compliance. Practically speaking, let's talk about how the other side may receive that notice and what could happen because of that. So I think that those are conversations to be had. I also think, however, that we as agents haven't normalized the use of this form effectively enough, and we're taking it personally. And it's not to be taken personally. It's that we have to have an understanding that this is how we help ensure all parties stay compliant with the contract. And I think I hate it when agents say, "Oh, well, I'm going to have to cure you for this." Well, no, say, "Hey, I'll need to make sure that we have this situation cured so that we have it on file, that everybody understands the timeline for compliance." Blame your broker if you want to at the end of the day. Say, "Hey, my broker tells me we need to cure for any non-compliances." Again, it's a love note. It's a reminder to comply. It's not intended to be nasty. So on the front end, don't treat it as such. Don't say, "Well, I'm going to have to cure you for it," or threaten curing. The cure should be normalized. This should be, hey, if we miss a date, we need to have a cure notice in place to ensure that all of the other timelines will be abided by, and those little reminders for compliance in that case. So I do think that a lot of it is how agents handle it, but I agree, Adriana. I think that that is a conversation that we need to have with our sellers. I'm definitely one where, while I like the cure and I like to keep people compliant, I get in some cases maybe that's not the best course of action. I will tell you, when it comes to things like Section 2B and close of escrow, though, these absolutely need to be cured.
For
But
sure.
but some of them I get. Even with the earnest money, I'm pretty forgiving. And again, I think this is situational. So let's say we went under contract on Friday, and I know that it says immediately upon contract acceptance, which should be, it's not defined, but we're going to take it as next day open for business. But maybe they're out of state and they've got to wire it, and they can't even get the wire instructions now until Tuesday, and then it's going to take a day to go. I mean, are we really curing in certain circumstances for that? Maybe. Again, I think that that's ultimately up to the seller. But I also understand, use a little bit of common sense with this. I'm not looking to cure for every possible thing in the contract either. I just want to try to keep us compliant. Anybody else? Examples, concerns, questions? All right.
Leah, I have a question.
Yes, yes, Katya.
Sorry, it took forever to find my mute button. If you issue a cure notice and let's say that they're not compliant with the close of escrow, is it recommended or would it show good faith if you send an addendum as well? Like, no, that's stupid. No, never mind.
No, it's not stupid. It's a great question. So there, strategically, we have actually done exactly that. So a prime example, we just had this a week ago, 2 weeks ago. We kept getting the, "Oh, it's going to close. It's going to close. We just have to do this. We just have to do that." So I finally said they need to put their money where their mouth is. So we're going to go ahead and we're going to issue a cure notice for failure to close. However, we're also going to issue an addendum that is going to give them to the date that they have requested, but they are going to agree that their earnest money is non-refundable if it fails to close by that date. So they decided to go ahead and sign that addendum. Had they not signed the addendum and they canceled on a loan contingency or a loan denial within that 3 days, they probably would have gotten their earnest money back. But we did both to say, "Hey, there's urgency and we're putting you on alert that you're out of compliance, but we're also going to give you the opportunity to get a little more time to close. But in exchange for that, you need to go ahead and make your earnest money non-refundable." So there are definitely points where issuing both might be just a solid strategic move.
Oh, okay. Thank you.
See, it wasn't a dumb question like you thought it was. It's a very practical one.
Thank you.
Anybody else? All right. Well, I hope you get the opportunity to issue a cure notice sometime this week. If you have any questions about these, of course, I'll upload this to my YouTube channel. But if you have questions about the forms, don't hesitate to reach out. And be sure to go to AAR Online to download a copy of this critical date list. That's all I have for you. Have a good day, everybody.
Thanks,
Thank
Leah.
you, Leah.
Thank you. You
Thank you,
too.
bye, Leah.
Bye.
Thank you.